We're excited. We're happy. At least we're put to rest the issue of zoning. The Supreme Court has restated its position as it relates to internal affairs of the political party. Thank you.
I'm Okpayo Kiro. I'm Southeast Legal Advisor of PDP, but for purposes of the issue in focus, I was counsel to the National Secretary of PDP in the case in which a Right Honorable Cosmos Ndukwe sought to virtually nullify the presidential primaries. He had filed a suit at the Federal High Court Abuja, contending that the PDP was under a constitutional duty to zone the presidential seats to the south. We raised objections at the Federal High Court, and the court gave a ruling that we didn't like. We appealed. PDP appealed. As a body, the national chairman appealed, and then the national secretary, whom I represented. And the Court of Appeal found our appeal right and struck out the suit for lacking merit and not activating the jurisdiction of the court. Well, Right Honorable Cosmos Ndukwe, in exercise of his right, appealed to the Supreme Court. And today, the Supreme Court gave finality to the matter by dismissing both the appeal and striking out the suit at the Federal High Court for lack of merit. Basically, that the issue is really the internal affairs of the political party. So for now, as far as I'm concerned, it's ahead, as we say, to Villa. There's no longer any stumbling block for the outcome of the presidential primaries of PDP. Yes, the Section 22 of the Supreme Court Act mandates the Supreme Court to look holistically at the case filed at the lower court in order to come up with a decision. The Supreme Court looked at it. That's why it evoked that power to strike out the suit rather than rehearing it and giving merit to it. So that's how they exercise the power.